Migrating to Australia podcast. Grant Williams here, pressing the buttons, driving the ship. I'm joined, as always, by Australia's favourite immigration lawyer. You're rocking the 3-day growth there, David. How are you?
Trying to recreate Don Johnson. Grant, I'm very good, mate. How are you?
You haven't got the pastel shirt on or the repulsive suits that he used to wear in Miami.
Not as good looking either. We've got a really good guest, a really special guest, a veteran of the family law circuit, a veteran of family law. Nadine Udorovic is partner at Nicholes Family Lawyers, and she joins us to talk about getting a divorce because we haven't touched on getting on a divorce. Nadine, it's great to see you.
Yeah,
thank you for coming.
David. Hi, Grant. Thank you so much for having me on this morning. This is wonderful. I'm very excited to have a chat to you guys about divorce and family law.
Hey, Dave, a couple of episodes in a row now, we've had a touch of glamour. We've had our Singaporean friend with his luxurious hair, and now we've got Nadine. Everyone gets to look at something other than our rude head.
That's it. We've got good faces for radio. Nadine, 20 years in family law.
Yes, long time.
And what I always think about with family law is cost, stress, tension, but it doesn't have to be like that, does it?
No, absolutely not, David. It certainly doesn't. And I think in this day and age, there's so much focus to try and get parties to access the alternative dispute resolution services, which we can certainly talk about in terms of mediations and so forth. And there's a lot of services available for parties. Obviously, the family court, the federal circuit court are always there. Our practice, we try to use it very much as a last stop if all else fails and all else has broken down. But, yeah, certainly it doesn't have to be stressful, doesn't have to be significantly costly. But, of course, there are many cases where that happens. Yeah.
You just can't get a divorce, can you? You've got to go through a procedure.
Yeah, so to get a divorce in Australia, you need to be separated for 12 months before you can actually apply for a divorce. And so once you've been separated for 12 months, you can then apply to the court for a divorce. It's fairly straightforward. It's just really filling out an application. The filing fee is now about $900, so it's quite expensive. Parties can either do it together or they can do it individually. So that really depends on where the relationship is at between parties. I've got a couple of clients at the moment who are doing it as joint applicants and then they share the cost. So really it's 12 months separation. A lot of the time we see that parties have separated under the one roof before they've had a formal separation. So if they have separated under the one roof for a period of time, sometimes there will be a requirement for a third party to file an affidavit to discuss the fact that they have, whilst they've been separated under the one roof, they have been living separately and apart. So the marriage hasn't continued. So it's really a formality. Most people do it themselves these days. We can do them, but we don't do a lot of them because of the cost involved of the lawyers drawing up the documents. We tend to say to our clients, if they can, jump on the family court website, download the form, fill it out, pay the filing fee. It then has to be served on the other party. You then get a listing date within about 4 to 6 weeks. And then once the divorce is heard in court, it literally takes about 5 minutes. Within a month after that, you'll get a divorce order in the mail. So it's pretty straightforward. The only time that it might require a little bit more assistance from a solicitor or appearances from parties is where there are children under the age of 18 years. Depending upon the circumstances, sometimes solicitors are required to attend court to discuss arrangements for children in terms of parenting and financial matters to make sure everything's okay. But generally speaking, that they're pretty simple. They've got listings pretty much every day, and there's hundreds of them that get sort of pushed through each week.
So young couples with no assets don't need you or anyone from your team. They can do it themselves.
They can do it themselves. And so what we find is we do a lot of parenting cases and property cases, and a lot of the time at the conclusion of those matters, a client will say, well, I want to get a divorce now. And sometimes they'll engage our services to do it, or sometimes they'll go off and do it themselves. In terms of getting a divorce and then how it relates, I guess, to a property settlement, is if you get a divorce, you then have 12 months from the date of divorce to actually obtain a property settlement Otherwise, you have to seek leave from the court. So that's really the only time it sort of crosses over and has an impact on property settlement. But there's no real rhyme or reason how people do it. Some people do their divorce first and then they think about their parenting and property after. Some people do parenting and property first and then they do a divorce. I've had other clients who never get divorced. They just don't do it. So it's very individual and personal in terms of how parties deal with their actual divorce application. But it can be very straightforward, David. But obviously we're happy to assist if necessary.
You're a senior lawyer. You've been doing it for over 2 decades now. Has it become easier? Was it always this way or was it a lot harder when you started in terms of process and procedure?
I think it's probably become a bit easier. Obviously, there's a lot of work in family law. I mean,
thanks, Malcolm's NBN. I'm sure she'll be back shortly. David, one thing that I was going to ask Nadine, and I'm sure you can answer this. Here we are. Nadine's back.
Nadine is back.
Nadine's back. Nadine,
yes, sorry,
that's okay. Thanks, Mr. Turnbull, for our NBN. Nadine, I was just about to ask David the question I wanted to ask you. How does somebody formally mark the beginning of a separation? Because you have to demonstrate 12 months. Yes. How can somebody do that?
Yes. So normally there is a discussion or some representation between the parties that they have separated. And it's a really great question, Grant, because in a lot of our property cases, the date of separation can actually have a big impact on the assets and looking at what the asset pool was at the date of separation. So we do often see cases where that date becomes a real sticking point. So generally you will see either one party leave the home, so that may mark the separation date. If there's a separation under the one roof, a lot of the time couples will move out of the matrimonial bedroom, if you like, and one party will go and sleep in another area of the house. But there's normally a discussion. I mean, one party will normally say to the other party, I want to get a divorce, or I want to separate. And Mark, you would see a lot of the time a separation of spending time together as a couple, going out together.
We'll just press on. If you were one of the parties wanting to separate, and let's say one did and one didn't, right?
That's what I was going to ask Nadine. Can somebody oppose a divorce?
Well, if David, should you perhaps, if you wanted people to recognise that the separation is happening, should you update your status on Facebook as a public declaration of intention? Nadine, what we were just discussing was in couples, often one person wants the relationship to end and one doesn't. So if you were the one who wants to leave, whoops, Nadine's obviously on the dodgy part of the internet. David, should you take that positive action to mark a date where you have made a decision? Like if you've just had the discussion, which may have been an argument, and you've decided that the relationship is definitely going to end, I want to end the marriage, and the other party might be saying, no, let's keep giving it a go. Should you go and change your status on Facebook so that there's a public recognition of the day that you decided what you wanted to do, even if the other party is contesting?
I mean, look, you can. I'd be very careful about using social media platforms in the context of family law situations. I've seen a lot of cases where people have misled. Sometimes it's been deliberate, sometimes it hasn't. Put things out on social media, and it's not necessarily a good thing to do in the context of a family law matter, particularly where there are children involved. So whether or not you change your Facebook status from married to single, I mean, yes, look, you can certainly do that and rely upon it. But if somebody is determined that they want the marriage to end, there's really not a lot that the other party can do to ultimately stop that from happening. You can't stop a divorce from going through. As long as you've met the criteria for a divorce, the court will allow that divorce to happen. So there are cases where the other party wants to try and stop it. I would say then that they need to access some counselling
We're having technical difficulties today, Grant.
Nadine does not live in a swinging seat. I'm going to guess that.
It's a really interesting point Nadine raises back there, because I was going to ask if unilateral opposition, if a spouse objects, so basically the court can just continue and proceed. Nadine, you're back. Welcome back. Nadine, if someone strenuously objects, does it take it longer for the divorce? How does that drag out proceedings? Typically, if someone, you were saying before, the court can carry on when one person wants a divorce and the divorce can be granted. What if someone objects? How much delay will the court allow, or will the court proceed on the same procedural basis as if it was a duly agreed to bilateral agreement?
They would still proceed, Dave, because if there's ever any objections, or, for example, what would normally happen is if there was any components of the application for divorce that the respondent or the other party wanted to object to, they file a response. So as long as the documents are filed in due course prior to the return date, the divorce goes through. It's heard and it's dealt with on the day. So there's not generally any real delay, specifically with divorce proceedings. They generally get heard within that 2 to 3 month period fairly quickly.
The reason I raised it is because I've had clients who have married Australians, and I've referred them on to you. People who have come from another culture, they're not aware of family law proceedings in this country, and the Australian partner says, no, I will not divorce you. And so the Australian partner bullies them into acquiescence to continue the marriage.
Yeah, parties who have been married overseas, they can still get divorced in Australia as long as we've got a valid marriage certificate, because that would need to be presented to the court. And as long as they have also met that threshold of the separation period, then the court will still allow a divorce to go through in Australia. Sometimes, though, depending upon where the parties may have been married overseas, they may need to then have the divorce recognised or considered in the other jurisdiction. And I've had a couple of instances where, as I said, depending upon whether it's been a religious marriage or a civil marriage, sometimes there'll be a difference. But as long as they've got their valid marriage certificate, they've met the threshold for the separation period, and all of that has been documented and evidenced, then the Australian courts can still order a divorce, and then they may need to have it recognised in the other jurisdiction if they wanted to.
The recognition in the other jurisdiction is not a precursor to recognition in Australia. The divorce in Australia can take place without recognition in the other jurisdiction, correct?
That's correct, yes. Yeah, that's correct. Yep.
Can you give us some examples of countries for people, because Grant will tell you we have people listening from many different countries. Is there any country that you can think off the top of your head where a marriage certificate is not recognised under Australian law?
Not necessarily, David, because, I've had cases where parties may have been married in India, or they've been married in other parts of Asia, or they may have been married in the States. And so if the parties have been living in Australia and they've separated here and there's a marriage certificate, then as long as they've met that criteria, the Australian court can recognise the divorce. And most of the ones that I've seen, one party has probably been an Australian citizen as well. So it really depends on the circumstances, but it's very common. Australia's multicultural country. So a lot of people that live in Australia that are married have not been married in Australia. It's very common.
Is it common for them, once they've divorced in Australia, to take their evidence of divorce under Australian law to the court or the relevant country court to have their divorce recognised elsewhere? Or is it basically once it's done here, people leave it at that?
From my experience, I think the majority of the cases, once it's done here, they leave it at that. I guess it would depend on then whether or not one of the parties was then wanting to go back to their maybe country of origin, or what the circumstances were around that. But from my experience, and a lot of the time we may not necessarily see it through afterwards, if they've required our services for a divorce, then that may well be the end of our engagement with them. But I think it's probably the majority would leave it at that. But again, I think it depends on the circumstances of them going back to another country to potentially live, or whatever it might be.
If someone's listening and they're a victim of domestic violence, which is a scourge and a real problem worldwide, if someone is a victim of domestic violence, does the court allow the 12-month separation period to be shortened in any shape or form?
No.
Okay. So they've got to leave, seek refuge, seek alternative accommodation, and still have the 12 months. Okay.
That's correct. Yeah.
Nadine, David mentioned that we are listened to all over the world. And David, we can welcome on Algeria and Ethiopia in the last couple of weeks. Hello.
That's wonderful.
Nadine, we have a no-fault divorce system here in Australia. Could you perhaps explain that it's not like those classic movies and whatnot? People don't have to be caught in the act of adultery or anything like that. That divorce is easier to get, shall we say, in this country than some others. Can you explain the no-fault part of divorce?
Yeah, of course. So we have a no-fault jurisdiction in Australia, which means that there doesn't have to be a reason for you to need to or want to get a divorce. You have to demonstrate the 12-month separation period. So many years ago that you need to have a reason, and I guess a lot of the time it would have been that there may have been an extramarital affair or whatever it may be. And I still see many people that often come to me and explain to me obviously the circumstances of a separation, and they may well be relevant in respect to parenting and property proceedings. They largely have no relevance with respect to a divorce application. The relevance really, where we see it in our practice, is the impact and effect that it has on parenting arrangements. And going back to what David was saying about domestic violence is unfortunately prevalent in a lot of family law matters, and I think that it's only getting worse. And certainly over the last couple of months, as a result of the impact of coronavirus and COVID and people being in lockdown, we've seen a huge influx of domestic violence cases across the board. And that may well be very relevant and often is with parenting and property matters too. So in terms of divorce strictly, no relevance.
It's a tragedy that coronavirus exacerbates the domestic violence. You said it's getting worse. I mean, pre-corona, could you say it was getting worse, or has corona made it visibly noticeably worse?
Look, if I look at my practice, even over the last 10 years ago, even 5 years ago, I certainly wasn't seeing as much domestic violence in our practice as what we see today. We have a lot of matters that cross over into the magistrates' court and criminal court jurisdictions where intervention orders are required, or family violence protection orders. We do a lot of work with child protection as well. And then sometimes a lot of our intervention order cases, parties will be charged, and then there are criminal proceedings that result as a result of those charges. So it's becoming a lot more common, unfortunately, which is really sad. And the impact then on children and the breakdown of a family, it can be absolutely disastrous. I think particularly in the last 2 months, we've seen a lot more of it as well. And I was saying to Grant earlier before we started the show that because a lot of these perpetrators are now they're in the home with these vulnerable people, whether it be the other partner or whether it be young children or adult children or other family members, being in lockdown and not being able to leave the home. I've got one client at the moment who's had to flee as a result because of being in that lockdown situation. It's really tragic. And I think it's probably, unfortunately, only going to get worse. And also because I think where you've got financial strain and people losing their jobs and the uncertainty of their future, there is an increase of domestic violence that flows on from that as a result. It's tragic.
People listening, there could be people listening, women who are from overseas on prospective marriage visas or on an 820 temporary as part of an 820-801 partner visa here in Australia. So we'll have people here with temporary residency and permanent residency. They may not understand the definition of domestic violence under Australian law, because under family law, because domestic violence, if you can explain to listeners, it's not just physical violence, is it, Nadine? It's psychological, it's the whole. Can you take us through it?
Of course, yeah. So it's not just physical violence, it's psychological, emotional, mental, sexual, and also now financial and economic. So examples may be where a party have separated, or they may be in the throes of separation and things aren't going well in the home, and you might find that one party cuts the other party off from credit cards, or stops their access to a joint bank account, or forces them to transfer all of their income into their bank account and doesn't give them any access to funds. That constitutes family violence. And they're new provisions that were added to the family violence legislation a number of years ago. So a lot of people think it is that you need to literally be beaten black and blue before you can say that there's been family violence. A lot of it is very passive aggressive, the psychological stuff that goes on for many years. I've seen a broad range of domestic violence, if you like. It's so far-reaching, and sometimes it can be very subtle, and a lot of the time those victims don't even realise that it actually is family violence until they tell their story to us, and we'll say to them, do you realise that because of what you're telling us, you could get this person out of the home? If you rang the police, they may issue what's called a safety notice on the spot and remove them from the home. Or if you went to the local magistrate's court and told your story to the magistrate, you would probably get an interim intervention order and be able to have them removed from the home. So, yeah, David, it's not just physical. There's a lot of other elements that go towards it. A big one that we are seeing a lot now is the economic and the financial abuse.
Unfortunately, a lot of women on prospective marriage visas here in Australia, or on 820 partner visas here in Australia, or 309 visas here in Australia, or even permanent residents who hold an 801 or a 100, don't understand their rights. If a woman listening wants to leave her partner, how do they come to you? Do they come to you directly, or do they seek a non-judicial, do they seek aid from you directly? Let me rephrase it. When do they come to you if they want a divorce?
At all different stages. So I talk to a lot of people who just want to come in and have a chat and who want to understand what their rights are if they were to separate. And I may never see them again, and they may stay in that relationship or that marriage for a long time. Sometimes parties are scared to leave because they've got young children and they're concerned about the future of themselves and their children, particularly if they're not working and they're concerned about being able to support themselves. I see people just as they want to separate, and we help them with an exit strategy. And a lot of the time that is because there has been significant and ongoing family violence, and we help them with an exit strategy, which is what I'm doing at the moment with one of my clients. So, or we see them after they've separated, and sometimes after they've had many discussions about the children and the property side of things, but then we have to step in and help them resolve it because they've reached an impasse and they can't agree. So we see parties at all different stages, David. A lot of the time it's because things are going really badly. They don't understand their rights. They want to know what they can do. We have a lot of women come to us from different organisations where we provide assistance, and we put them in touch with different shelter organisations, if you like, to help them if they need to flee the home. So there's lots of different avenues for us to provide support, but we see people at all different stages. Sometimes we see them just as they've left, literally that day or the next day, and they're in absolute crisis and they need to seek immediate assistance for themselves and often children. So it really depends, but we're equipped to see people really at any time.
Compulsory family dispute resolution, that's compulsory. When do parties get to that stage, and how quickly after that do they get their day in court?
Yeah, so a lot of the time parties will go off and have a bit of alternative dispute resolution or mediation prior to issuing. There is an expectation that before parties issue for parenting proceedings, for example, in the court, unless there's circumstances of urgency or risk, there is an expectation that they've undertaken some form of alternative dispute resolution. Sometimes it's through Relationships Australia or various mediation centres. So there is that expectation. But through the court process, once you file now, for example, with property matters, the court will now order a mediation in every property case. Now, we do a lot of mediation work for a lot of parties who never see the inside of a courtroom, and they use the mediation process as a way to resolve matters with barristers as well. So we can have a mediation and set it up exactly the same way as the way we would have to set it up if it was court ordered. normally you will get a mediation ordered after your first court date. Generally, it happens once the interim issues are resolved, but it really depends on the circumstance of the case and what the issues are. But you would expect that you would have to have some type of mediation at some stage, but then there are circumstances in some cases where, for different reasons, a mediation will not work, but also where there is domestic violence, we can still have a safe mediation. The parties don't need to be in the room together. They don't necessarily need to be at the same venue. And at the moment, because of COVID, where we're working remotely, we're doing mediations on Zoom now as well. So there are lots of different options to help people depending upon their circumstances. And again, also where you go to court and you have conciliation conferences or case assessment conferences for property matters, again, the court have safe rooms. They're equipped to help people in need who don't feel comfortable for whatever reason sitting in the same room with their other party. So we've got lots of services available to help, and it's very much on an individual needs basis depending upon the case and the personalities and the parties involved.
The mediation, does that have to be endorsed by the court, and how is it endorsed by the court if it's done remotely?
Yes and no. So it will be endorsed by the court if there are proceedings on foot. The court will make an order for mediation, and that will then involve the parties each briefing a barrister and having a mediator who's also a family law barrister, or sometimes a commercial barrister, depending upon what the nature of the property case may be. And then we will agree on a venue, we'll agree on a day and agree on starting times and so forth. We normally allocate a full day for a mediation, and you have to exchange a mediation position statement prior. So that really is a very concise summary of what the case is about. And then generally it will give the other party an indication of what that person's position is going into the mediation. So it will be endorsed by the court, and they are court orders, so they need to be adhered to. But as I said to you earlier, we've got many property cases and parenting cases that don't have litigations, but we will still have a mediation if we think that it will benefit the parties and it would potentially lead to a resolution. And look, mediations are great. A lot of cases settle at mediation. So look, I love mediations. I think they're fantastic, but I'm also collaboratively trained, so collaborative law. So I do a lot of collaborations, and so do a number of our other partners at the firm. So that's another form of alternative dispute resolution, and it's an American concept where the parties contract not to go to court. So they sign what's called a collaboration contract, and they each appoint a solicitor. Often we'll have a psychologist involved if there's complex parenting issues, and we can also have an accountant involved. So that's a process where you actually do sit around the table with your other spouse and your solicitor. So if there has been domestic violence, or if there is a real inequality between the parties, sometimes that process may not work. And so we have to make sure that the personalities and the parties involved are right for that. But collaborations are fantastic because the parties really own the process. They ultimately decide on how they want their assets to be divided, but with the guidance of their lawyers and an accountant. They also will agree on how they want to have their parenting arrangements structured with the help of a psychologist if necessary. I've done a lot of collaborative work. So far, I think I've got a 98% strike rate in terms of success with collaboration. So I think it's another form of alternative dispute resolution. That is not something that the court would order, collaboration. It's something that if parties are interested privately, as long as their practitioner is collaboratively trained, we can have a collaboration. And normally it takes 5 or 6 meetings and the case should be settled. And we draw up settlement documents and court orders similarly to what you would get through the court process. So it's another offer that we have at our firm that I guess sets us apart from a lot of other firms that don't have the collaboratively trained professionals. So I think it's another really good way for parties to try and reach a resolution.
Nadine, a lot of our listeners won't be familiar with the Australian legal system, and you mentioned the term barrister, and we've been talking about court, and that I think we mentioned courtroom. A lot of the way that the legal system is portrayed in popular media is panelled courtrooms, wigs, gowns, gavels, order. Family law
it's nothing like
is
that.
not like that, is
Really.
it? I mean, family law is the way that it's handled in practice. It's a very supportive environment for somebody who needs it, isn't it?
That's correct, Grant. Yes. So, look, I mean, our barristers will be often their robes, so they've got their gowns and so forth, but it's not like you see on the movies. There's a lot of structure. Cases are listed on particular days and at particular times. You generally get docketed to a judge that would see you through your entire court process, depending upon availability and so forth. So there is a lot of order and structure to it. There's also duty solicitors on hand to help parties who can't afford legal representation. So if they turn up to court and they can't afford a solicitor or a barrister, there are duty lawyers who are available. Although I will say that obviously, given the amount of cases that we have in our jurisdiction, both across the family court and the federal circuit court, the duty solicitors there's simply just not enough of them, and they don't have enough time to really give the individual advice that's required. So I would really encourage litigants who can afford a solicitor or a barrister. I think it's really important to have a representation. There's a lot at stake for people who are going through family court matters, whether it's about your children or your property. The stakes are high, and when you don't understand the system, you can get lost and things can go wrong. So I think representation is really important.
You mentioned, Nadine, the family court and the federal court. What determines which court the matter goes to?
So the family court generally see more complex cases. So, for example, if you've got a property case where the asset pool may be, say, $500,000, we would issue in federal circuit court. Where you've got more complex issues and where you've got a much higher asset pool, or where there may be some complex commercial issues with respect to property, or where you've got a sexual abuse case with respect to children, or a very complex parenting case, you would be issuing in the family court. So there's generally a distinction between where cases are listed, and that's then how we sort of, look at where we file.
If a person has assets offshore, how are they discovered under Australian family law?
So that can be difficult, because obviously assets that are held within our jurisdiction in Australia, we can issue subpoenas, we can subpoena persons to come to court in person. It is easier to find those assets, but we do a lot of international family law work, both with respect to children and property. And a lot of the time there is assets outside our jurisdiction. Sometimes we'll need to engage the appropriate persons overseas. So, for example, if we know that there's real estate, for example, in the UK, we've got contacts all around the world where we can engage a UK property lawyer or a UK agent to do some fact finding and tracing and look at some overseas assets for us. But it is obviously a lot more difficult. So it really depends on what the asset is and where it is, for example. It's not as simple as just filing a subpoena to a English bank account. But sometimes there might be other proceedings at some other point on foot in another jurisdiction. So, yeah, overseas assets are a lot harder to trace, but there can be ways to certainly investigate. And I've got a couple of cases at the moment where there are assets overseas, and we're looking at different ways to try and gather information.
It's a fascinating and incredibly complex area of law, and I always panic if a couple comes to me and one of the clients is from overseas and a temporary resident or a permanent resident, let's say for the purpose of this question, they're a permanent resident or a citizen, and they want a divorce. My reaction is, well, you must see a family lawyer. So, I mean, as a consequence of our discussion today, it's not always necessary to engage a family lawyer, but is it fair to say it's important to see a family lawyer and have an objective third-party opinion on whether you need representation?
Absolutely. That's exactly right, David. And look, sometimes we see people for second opinions as well who have already got another lawyer, and I think sometimes that's a good thing also. But I do think that it's information and knowledge is power. So it's good to know where you stand. And it doesn't necessarily mean that you need to engage a family lawyer. And I don't think that people should be scared also to engage family lawyers. because a lot of the time it's really necessary, and sometimes it's just really hard for the parties to talk about what they want to do with their children and property, and understandably, because it's such a complex area, it hits at the core, doesn't it? They're your children, they're your assets that you've worked so hard for. It's really what makes up everybody. So sometimes I think for everybody, get the advice, get it sooner rather than later, I think also is really important. And then weigh it all up. And if the parties can reach agreement about whatever the issues may be, fantastic. But then I also think that it's important where you have children and property to get a lawyer to document that settlement for you. Because I've seen a lot of people who have divided their assets, for example, and they've never actually signed a consent order, or they've never had a binding financial agreement. And then years later, an issue arises and they'll say, but I had a property settlement. And I'll say, no, you didn't. You may have divided your assets, but you haven't documented it. So you technically haven't had a property settlement. So there's things that, people can trip themselves up on. So absolutely, David, get some advice, come in and have a 1-hour consultation. You'd be surprised how much we can get through in an hour. We really can give advice with respect to assets and children within an hour. We can cover a lot of ground. And then once you've got the information, you can weigh it all up and decide how it needs to proceed from there.
My final question, Nadine, when somebody is looking for a family lawyer, what are the 3 top considerations?
So 3 top considerations. I think you want a family lawyer who is honest with you. There's no point how I run my practice is sometimes it's not good news what you have to say to a client. But I think it's better to be honest because it sets your client in good stead. There's nothing worse than having someone who's given you really bad advice and you've continued to follow that bad advice, and then 2 years down the track you hear it from a judge that it's actually not going to go that way. So I think honesty is really important. Obviously, knowledge. You want to go and get advice from family lawyers who are specialised in the area, who have been practising, who know the court system, who have run cases, who really know the law and keep up with the law. So I think honesty, knowledge, and also I think integrity. I think that's really important with anything, but particularly if you're looking for a lawyer.
A lot of people don't understand it's more than family law. So you are expert in tax law, superannuation law, property law. It's a multidisciplinary.
It is. Look, so, we're obviously family law specialists and we very much have a holistic approach to our practice. So we often will engage an accountant, a financial advisor, a psychologist, a psychiatrist, a commercial lawyer, a property lawyer, sometimes a superannuation expert, a tax lawyer. So whilst we have a broad brush, sort of a broad view, understanding and knowledge of some other areas of the law, we're certainly not experts in those areas, but we understand when we need to reach out to other experts and bring them into our cases to give us specialist advice. And I think that's also another thing that probably sets us apart from maybe other practitioners is the holistic approach that we take. We don't put ourselves out there to say that we're specialists in areas that we're not. We're family law specialists, but we do work with a lot of other professionals to make sure that our clients get a full advice. And that's really important because there can be a lot of complexities that come into family law matters. It's not just family law. As you say, it crosses over into so many other areas. Yeah.
Nadine, it wouldn't be a Migrating to Australia podcast. Whenever I have my last question, Grant always has one question himself. So, final question.
Just before I launch into the final question, David, just remember that the information contained within this podcast is general in nature and that you should not act on the information in this podcast as specific legal advice. If you want specific legal advice, you should catch up with somebody like Nadine. And, of course, if she pops back in, because
she's got a wedding to go to, so we better wrap it up. Nadine, are you there?
She's not, but look, what you can probably answer this, David, and I think this is relevant to our audience. Is the legal system now, when it specifically relates to divorce, it's got its roots from the English tradition, but is it now very culturally aware about the needs and obligations of clients with different religious and cultural backgrounds?
I wish Nadine was here to answer that, and I want to say I hope so. But Nadine could confirm the correctness of such a question, such a thought. I would hope it was, but Nadine's not around to confirm. I would hope it was.
Yeah, what a bummer. My best question for weeks and weeks. And there's nobody here to. Here we go.
She's back.
Nadine is. Hang on, I just need to click her back in. Fantastic. Here we go. As the internet.
I'm back.
She's back.
Grant's got one last wonderful question, Nadine.
Nadine, yes, I was just lamenting that I came up with a really great question.
Sure.
And the legal system we have here is rooted in English tradition, Christian, etc. How culturally sensitive is our legal system as it exists today, and as you operate within it, for people from different religious and cultural backgrounds who may have different religious and cultural obligations?
Look, yeah, I mean, we're very culturally sensitive, and I think sensible as well. I mean, I have clients from all around the world, from all different backgrounds, and the family court and federal circuit court are well equipped to deal with that. So, yeah, look, for me, I have a lot of international clients, and for example, where we have parties who have language barriers, which can often happen, we involve an interpreter. So we really try to make the process as easy as possible for our clients. And we're very understanding of those circumstances, because a lot of people that we see weren't born in Australia, and they have come from very different cultures and upbringings. So we try to be very sensitive and I think sensible to that. And I think that our family court jurisdiction are also.
Thank you for coming on, Nadine Udorovic, partner, Nicholes Family Law and collaborative lawyer extraordinaire. Lovely to have you on.
Thank you so much, David. Thank you, Grant. I really appreciate it, and I hope you enjoy the rest of your weekend. And David, no doubt you and I will talk soon with lots of our cases that we have.
That's it, Nadine. You have a good day. Ciao. Thanks for coming.
Thank you. Thanks guys. Bye. Bye-bye. Bye.
Well, David, there's not really a lot more to say other than to be sure to encourage people who are thinking of ending a significant relationship, marriage, obviously, but it also applies to people
couples as well,
who are de facto and don't have a certificate of marriage.
Or registered under state law. That's right. So it's really important, because you don't know what you don't know.
That's right. And look, in the sense of access to children and dividing up property, if you've been cohabiting for how long, David, that you get treated the same as if you are married?
I always thought it was 12 months plus.
Yeah.
I always thought it was 12 months plus. But, yeah, Nadine could tell us, but she's off to her next Zoom appointment. Zoom's getting a lot of use, but we don't use Zoom for this. What do we use? We use StreamYard.
We do, and I'm always playing around with other things. Zoom's got its pluses and minuses, but StreamYard's better for what we do, because we send this to other places on a Zoom.
You can't with Zoom.
People within, but we want people to be able to access it no matter where they are. And for some places, Facebook, for a lot of people could watch it on Facebook and they don't chew up their mobile data.
God, very strategic. I like that.
In a lot of countries and a lot of places, that Facebook doesn't count against your data. Facebook pay the mobile carriers to actually not time or not have the ticker running against Facebook. So that's the reason for
that's very strategic. I like that.
Well, David, you know that I'm always thinking about something. Now David's turned his camera off.
I've got my next Zoom appointment.
Oh, well, there we go. I will end our podcast here, David. I'll just say that the information contained within is general in nature, and if you want specific legal advice, reach out to somebody who is a qualified and registered practitioner in that area. Nadine in family law, and she's at Nicholes Family Law. And, of course, David Bongiorno, who you can reach out to on Twitter.
David Bongiorno.
Bongiorno.
At David Bongiorno, DAVID, Bongiorno, BONGIORNO, all one word.
Or hit the Migrating to Australia podcast.com website and click on the Make an Appointment with David button, and that can make all things possible. If you just listen to the podcast and take action without seeking advice from an expert, David, what are you?
You're a galah, a goose,
a drongo.
gander, a drongo. All of the above.
All right. Well, that's been Migrating to Australia podcast on divorce.
Ciao, Grant.
Thanks, Dave.